Hi, this is Joe from McClear Law Office. Thank you for tuning in to Family Cottage Estate Planning, recorded live at the Oshkosh Senior Center. This seminar covers elements of both estate planning and long-term care planning as they pertain to secondary properties. This is only an introductory seminar, and it is recommended that all who wish to engage in estate planning and long-term care planning first consult with an experienced attorney. Thank you and enjoy the presentation.
So, disclaimers up front. This is for the folks here and for the folks watching it later. This is information pertaining to Wisconsin law only. If you have out-of-state property, it might be a little bit different. If you're viewing this from someplace else, find a local attorney. Attending or viewing this seminar does not establish a lawyer-client relationship. That should be obvious, but I want you to know it sounds silly to say that this is a legal presentation, but we're not going to consider it legal advice to you individually. If this was legal advice, it'd be accompanied by a bill. Okay, so there's no lawyer-client relationship established, so you know that now. Now, this is an introductory seminar. The things we're going to be discussing, there's going to be 4 points. This is very rudimentary. This is the opening door of understanding these areas of the law. So nobody's going to walk out of here an expert, but ideally you're just going to understand the basics of what's important in that area of the law and have it be the first step to finding out which questions you should ask for your own plan. In other words, go talk to a lawyer. So the family cottage or cabin. Now, when I think of the family cottage or cabin in this state, this is the image that I use on a lot of my advertisements here. So you don't see the cottage, but you see what's so great about it. It's out there in the woods, in the quiet, by the water. This is what I picture. This is what I think of as up north or up north. Now, I met a lot of people who have, their families have secondary properties north of here, and they like to spend their, weekends or long vacations there as a family. But this covers more than just the cottage or a cabin. This can cover hunting land as well. You have a parcel of hunting land that your family uses. This information here can be utilized well for that as well. And the family cottage doesn't necessarily have to look like what I just showed you before, if you were to have actually a condo down south. Now, I mentioned out-of-state properties might be a little different, but we could still work with them. And this information can largely cover to be used to protect and to pass on that secondary property that maybe you winter at. There are going to be 4 issues today. The first one is, will it even be there after I'm gone? And by here we're talking about, will it be swallowed up due to long-term care costs? This is a presentation that would be covering hours in and of itself. So again, this is just the dipping our toes into these waters of protecting assets from long-term care. And here we're talking specifically about secondary properties. So some quick facts. I always start off with the scary stuff. Upwards of 70% of folks who are 65 or older will require long-term care at some point. When I say upwards, technically the figure is 69%. It all depends on what your definition of long-term care is. If you don't include rehab assignments at long-term care facilities, then it's more about in the 50%. But if you were to include rehab assignments at nursing homes, then we are in the area of 70%. That's for individuals. I don't have it listed here, but if you play out the math, that means for a married couple in this age range, there's a 91% chance that at least one will require long-term care in the future. And of course, it is expensive. That is no secret. In this area of the state in Oshkosh, 2021, the most recent figures from Genworth say it's about $110,000 a year for a private room at a nursing home. That's actually a dip from previous years. I think we can credit a lot of it to what happened last year with the pandemic. That's actually been a dip because it was closer to $120,000 just 2 years ago. I would expect it to get back to $120,000 quickly, and by the end of this decade, we're probably getting close to $150,000 a year. If you don't have long-term care insurance, you will have to spend down your assets to pay for your care, because Medicare is not going to cover your costs. They may cover your rehab assignment. If you go in for surgery and you come out and you go to a long-term care facility for rehab, it may cover all or some of that cost for a couple of months. But that's about it. If you're in for the long haul, Medicare is out of the picture. Medicaid is the federal program administered at the state level. So while it's a federal program, each state will have its own guidelines and rules. They cover the long-term care costs once you've reached your asset limits. Those can be pretty low, particularly for single individuals. I won't go into the specifics here, but trust me, you're not going to have a lot, particularly as a single individual, before you qualify for Medicaid. Medicaid will allow you to keep your home and still qualify, whether you're married or single. They will put a lien on the home if you're single and try to recover after you're gone. But they won't make you sell your home. You can still qualify for Medicaid and have a home of immense values, particularly for this area. But Medicaid will very likely not allow you to keep a second property. There are small avenues to maintaining a second property, but it doesn't fit most people's lives. For the most part, if you have a second property in any state, they're not going to let you qualify for Medicaid while you still have that property. So what does this mean? You will have to sell your second property to pay for your long-term care. And then once those proceeds dwindle, then Medicaid would come into the picture. So what can you do? My first bit of advice, plan for attack, is get long-term care insurance. Now, the industry has evolved over time. I'm not in the industry. I'm not in the long-term care insurance industry. But I know a little bit about it. I know traditional plans, which operate much like healthcare insurance, where you pay premiums, they rise every year, use it or lose it. You don't get to get your premiums back if you pass away at home. Other forms are more asset-based. So if you pay into it, but if you don't use it for long-term care, the money can come back to your family. You would just be sacrificing most likely a lot of the income you could earn off of those assets. Some policies are available to people up to 80. Now that's what I've heard, never seen it, but I've talked to vendors of long-term care insurance and say, you really want to get it in your 50s, maybe 40s, but if you're not at that point, and you're still in your 60s, even in your 70s, there still may be options for you. And I advise everybody to look into it if you do not have long-term care insurance. Not saying you have to purchase some, anything that comes your way, but look into it. But if you do not have long-term care insurance, or you don't have much in the way of benefits, the option that I would come into the picture with would you place your cottage in what's called a Medicaid trust. I'm not going to go into the mechanics of what a trust is today. That's another full seminar in and of itself. But a Medicaid trust is a unique type of trust that its main purpose, it has many benefits to it, but its main benefit is that Medicaid Trust 101, your assets that you put into your Medicaid trust, they're not considered during a Medicaid asset evaluation. So when I say that Medicaid has stringent and low asset limits, they will consider everything that's in your name, everything that you own, but they will not consider assets in a Medicaid trust. This is not a loophole that they forgot to consider. This is written into the actual rules, saying that everything that you own is on the chopping block, but if you have something in one of these types of trusts, we're not going to look into it. So don't think you're gaming the system here. You're just playing by the rules. You can still use your second property the same as you do now. You visit it whenever you want. You can even rent it out. If you were to utilize it, say, with Airbnb or Vrbo, it used to just be VRBO, now they go by Vrbo. So you rent it out for a weekend or a week or a month at a time to individuals. You can still do that, and you can profit off of it. This doesn't work so well for other assets as it does for real estate. But real estate is a wonderful thing to protect in a Medicaid trust. So I love protecting real estate in Medicaid trust because you do not give up your ability to enjoy your second property and to, if you were to, rent it out to profit from it as well. Now, under current laws, your property will receive a full step up in cost basis, which means that it doesn't matter how long you've had that second property, if you've had it for 30 years or more, or if it was gifted to you from your parents and so the cost basis is back from the 50s or so, it doesn't matter. If you have these assets in a Medicaid trust, when you pass on, it will receive a full step up in cost basis, and that will greatly reduce or outright eliminate capital gains taxes for your family if they were to sell it after they receive it. Capital gains taxes is another full seminar, but we'll just say that it could save them a lot in taxes, thousands or even tens of thousands of dollars, depending on how long you've had the second property. And like most trusts, by centering your plan around a Medicaid trust, you can have your family avoid probate after you pass on. Probate takes about a year in this state, costs a bunch of money. People like to avoid that when possible. If you do it right and you center your plan around a Medicaid trust, you can avoid probate. Now, Medicaid trusts are expensive. Okay, more commonly utilized trusts, I think, particularly when it comes to estate planning, is revocable living trusts. Medicaid trusts tend to be more expensive than those, twice the cost or more. But usually the expense is less than a single month in a nursing home, sometimes less than 3 weeks in a nursing home. So yeah, it's a big cost, but it's an investment in protecting assets for the future. Because if you don't do it, then the values that you are hoping to leave to your family after you're gone, they're going to be swallowed up quick, fast, and in a hurry. And as it right here, just a couple of weeks in a nursing home will likely outpace the cost of a Medicaid trust, depending on the attorney you're working with, essentially. They can allow your family to avoid probate costs as well. So not only preserving the assets, probate costs can be expensive in the back end, more so than trust administration costs usually. So you're having your family save not only time, but those costs on the back end as well. Now here's something to consider. Should I just give it to my children? I have this cabin, I have this cottage, I have this hunting land, I have this condo. Should I just give it to them when I reach a certain age, deed it to them, so it won't be in my name when I apply for Medicaid? So it won't be an issue. And then it avoids probate because I already have it. My thoughts on this is right now, at this time, probably not. The one reason is you would not be giving them the step up in cost basis. So whatever your cost basis is for that property now, you'd be giving that with them as well. If you die with the property, then you get a step up. If you give it to them, there's no step up. So if they have to turn around and sell the property, they're probably going to be hit with a fair amount of capital gains taxes, possibly thousands, possibly tens of thousands of dollars. Now, I say that's right now. Current administration and Congress have been talking about altering or eliminating the step up in cost basis. I don't think that's something they're going to push quickly. Not anymore. There's got other problems, but they are considering it. So maybe the gifting option, at least from a tax standpoint, would be viable in the future. But as for right now, I'd say it'd be a big tax mistake. And you'd be missing out, if you were just to give it to your kids, on additional planning opportunities that could help keep the cottage in your family. That's what's going to be coming up next. More on this later. So issue 2, and after this issue, I'll take a break for questions. Who wants it? Really? Who wants it? Now, maintaining a second property. It's great, right? But it's work as well. Now, particularly there are expenses, same expenses that you'd be paying. I mean, assuming you have the mortgage all paid off already, you still have taxes, insurance, utility, upkeep. Somebody's got to make sure that the lawn, the weeds are taken care of, that the snow is removed. So there's costs. And is it even nearby? Maybe it is for you, maybe it's just a couple hours away, but what about for, if you're going to leave it for your family, are they still in the area? Or are they out of state? So, how to leave it to your kids. If you have one child, that's easy, right? There you go. But if you have more than one child, it can get a little difficult. It can get difficult because you have to ask them, and you should do it soon. If you have a second property, you didn't think you'd have to ask this, but do you really want the cottage or the second property? They may like visiting it, but do they really want to own it or co-own it? That's a totally different animal right there. So they like to visit it, but how often do they visit it? Are they out of state? Do they just come once a year, maybe for the holidays or for birthdays or for once or twice in the summer? So yeah, out of state could be quite difficult. Do they really want to put up with the costs? If they're only going to visit it once, maybe twice a year, is that worth the cost of maintaining the property? So you consider a couple of things here. Can you divide up the estate in such a way that the child or children who really do not want an ownership interest in the cabin, can they get a bigger share of the rest of your estate? I know people want to be equal with their family very, very often. They want, if they have 3 kids, they want to split 1/3, 1/3, 1/3. If they have 10 kids, they want 1/10 each. Sometimes that's not the case, but more often than not that it is. So do you have other assets in your estate that you can draw up your estate plan such that the people who want the cabin perhaps would get a lesser share of your retirement account or life insurance or the sale of your residence? Often you can, but if you can't, consider supplementing your estate with additional life insurance. This is something that farmers often do. Farmers have several kids, but usually, if they're lucky, one of them wants to farm. The other ones, they've moved on. They moved to the city. They're doing something else. They want to be equal. The farm's the majority of their estate. They don't want to cut out their other kids, so they purchase additional life insurance. What's really good in these circumstances are second-to-die policies if you're a married couple. You can get a much better death benefit on a second-to-die policy. So if you have the assets in your estate, you say, well, even if we have these 2 kids have no ownership in the cabin, they could still be equal with everything else. Great. If not, but you really, really, really don't want to look like you're playing favorites, talk to an insurance agent and talk to about policy options that could help you out. Now, issue 3, for those who do want it, how can I make them play fair? So here what we're talking about is using an LLC in your plan. So, what can happen with multiple owners? Particularly if they own it outright. Usually it'd be as a tenant in common. So they all have a share in the asset, in the property, but they all have equal rights and use to it. If 3 people own the cabin as tenants in common, and they all want to go there at the same time, July 4th, and I'll show you later, they all have the right to do it. All owners are responsible for the expenses, but who is going to write the checks? Is one person going to collect it all from the siblings? Or are they all going to write individual checks? What happens if all the owners want to bring their families to the cottage on the same weekend? July 4th, Labor Day, Memorial Day. Wait a minute, I want it this weekend. You had it last year. Yeah, but you had it 2 years in a row before that. Who sets the rules? Nobody. And what happens when an owner wants out? They want to cash out. All these things could be difficult. So maybe utilize an LLC, which is a limited liability company. These are not just used for businesses. Very often they are. I have an LLC. But they can be utilized for secondary properties as well. Because what they do is they establish rules that must be adhered to that can make people play nice, essentially. Even though you, the referee, are no longer around, you leave the rule book that they have to adhere to. So instead of leaving it outright, you leave them shares of the LLC that owns the cottage. So it's not, they don't own the cottage outright, they own a share of the LLC. The LLC owns the cottage. It sounds convoluted, but it's really not. With the LLC, as I said, you can leave behind rules. So let's talk about the rules. You memorialize these rules in what's called an operating agreement. You can set that up now. You form the LLC now and you set up the rules now and make it really difficult to change. You can determine how the manager or managers of the LLC will be selected, or you can pre-select the manager. The manager will be the one who passes the hat around to collect the expenses from the other siblings and cuts the checks and can set the schedule for the cottage. Okay, child A gets it on Memorial Day, child B gets it on 4th of July, child C gets it on Labor Day. Next year we'll do something else. It's all within the authority of the manager. You can say what happens when one of your kids does not pony up their share of the expenses. They haven't paid their share of the taxes, they haven't paid their share of the insurance, utilities, upkeep, yet they're still utilizing the cabin. So what happens? Well, some things that can happen is they lose some or all of their ownership. Child A has not been paying their share, so child B picks up the shortfall and pays it all. Now, child B absorbs some of child A's interest. So where it was a third, now maybe it's 25%. With my understanding, there would be no math. But okay, 25%, 40 some odd percent, 33%. So there's more and more interest. So if they do end up selling it, then the child who actually pitched in to cover the cost would be receiving more of the proceeds. And voting rights. There are often voting rights in LLCs for all the members. And the more ownership you have, the more powerful your vote is. You can say what happens when an owner wants out. An owner says, well, I own this share. I'm not really interested. I don't want to keep up with the payments. I don't visit enough to use it. You can establish right of first refusal, so they can't just go to an outside agency right away and sell their interest. They have to turn back around and offer it to their family first. And you can say that must be done at a family discount. 10% off fair market value, 15% off fair market value. I wouldn't go crazy and say something like 50% or more, because then you'd be messing with the cost basis of the asset. But at least, too much. So give them a nice discount. Then if the family all says, no, we don't want it, then they could theoretically turn around and sell it to an outside agency. There are other rules you can utilize with an LLC with regards to what happens when a member passes away. Can they leave it to a spouse? Can they leave it to a non-spouse, somebody else? You can set up rules about what happens to the share once the owner passes away. Notes on LLCs: your trust can own your LLC, which can own your cottage. Again, sounds convoluted, but it's really not. All the while, particularly while you're still here, you continue to use your cottage like you always have. Nothing changes, even your taxes. I can't say the same thing after your children inherit it. They won't necessarily pay any more taxes, but they will have to likely have an extra filing for their inherited shares of their LLC. Unless it's a single member. You leave it to one person, only one person has it, then nothing changes about that. The LLC can provide liability protection for the owners should you rent out the property. Now, there's a lot of I's to dot and T's to cross for this, but the big benefit of having an incorporated company, including an LLC, which doesn't have to necessarily be a company that makes money, is that there is a fair amount of liability protection. If something happens on the property by somebody who's renting it out, they injure themselves, you have a greater chance of them not being able to come after your assets, your life savings, your anything else you have, your stocks. Greater chance that they will not be able to come after it if you have them in an LLC. And nonetheless, you should still get an umbrella policy if you're going to lease out the property to cover these types of incidents. One more issue. Can I protect the cottage and keep it in the family after I'm gone? Now, I'm not talking about the cold dead hand. that keeps it in their family no matter what anybody wants. I'm saying if your family members want to keep it, is there anything you can do to make sure that it happens? No matter what happens after you're gone? And the answer is yes, and you can utilize spendthrift trust planning. Oh, great, another trust. We already talked about revocable trust, Medicaid trust, and now spendthrift trust. Good news is you don't have to form the spendthrift trust now. They are formed during the administration of your estate. So it's nothing that you have to worry about now. You leave the rules in your current estate plan for them to be formed after you're gone. Why would you want to do that? Here's why. When you leave an asset to a beneficiary outright, it comes subject to all the liabilities of that beneficiary. A lot of things in life can knock you on your backside and empty your pockets and empty your bank accounts. But if you leave an asset to a beneficiary in a spendthrift trust, that asset will receive an immense, and I'm not short selling this, I'm not overselling this, an immense level of protection from liability of the individual. So what do I mean? Protection against divorce, that's a big one. You leave an asset to a spouse or to a married beneficiary, and then their spouse leaves them somewhere down the line. Well, what you left to your beneficiary could be subject to the taking in divorce proceedings. Not so if you leave it in a spendthrift trust. That stays with your family. Lawsuits, contract disputes, personal injury, your kid is driving down the road, hits somebody in a crosswalk, or crashes into a van full of lawyers. Problematic. They could be taken to the cleaners, but if you leave your assets to them with spendthrift protections in a spendthrift trust, that's going to be safeguarded. Creditors and bankruptcy even. They start a business, it goes belly up. Sometimes it happens. They have to file for bankruptcy. The bankruptcy court will be looking to see what they can use to pay off the creditors. They will not be looking into a spendthrift trust. So they can hold the interest in the cottage or other property, either as owner, co-owner of the property outright or owner of the LLC, along with any other inheritance that you leave them. You can leave the entire amount that's going to them in these spendthrift trusts. And they would nonetheless have full control over their inheritances. So while it's in this trust that has this immense amount of protection, they can still utilize it, spend the assets, invest the assets, sell, buy, as they would right now. There's some extra paperwork, as I said, when it comes to tax season, but nonetheless, it's quite worth it to have this immense amount of protection. Now, this is something that I could not create for any of you. So, giving yourself spendthrift protection and maintaining full control over the asset is something that Wisconsin does not allow. Other states, you can form these types of trusts if you can pay through the nose for them. They're very expensive. They're usually for people with high income but high liability. So think surgeons, plastic surgeons, of the like. So they can afford these types of spendthrift trusts where they can still have control over what's in the trust, but if somebody sues them, what's in the trust is safe. I can't make those for you. I can make them for your children. So let's wrap it up. Let's talk about the ultimate plan for your cottage. What would it look like? First of all, you talk with your children, find out who really wants the cottage and who would rather not have that ownership interest, and you adjust your estate plan accordingly. Step 2, you create an LLC for the cottage. You draft an operating agreement that states how a manager will be picked, what happens when a co-owner does not chip in on expenses, and how a co-owner can cash out. Then you transfer your cottage into that LLC. Step 3, you transfer your LLC into your Medicaid trust. Now you're minding that Medicaid has a 5-year look-back period. That'd be for gifts or for transferring assets into one of these trusts. So if you think, boy, I'm going to be needing some long-term care in the next year, really consider what you're doing. Not saying you can't utilize a Medicaid trust at that time, but there could be some issues that you have to really, really work around. So this trust will protect the cabin from the long-term care spend-down requirements and will very likely serve as the centerpiece of your estate plan, which will include spendthrift trusts for your children. So you call for the transfer of your children's respective inheritances and say that could be an equal share in the cabin or the LLC. And they each get their own spendthrift trust for themselves, where they will have full control over their inheritance and protection over their inheritance as well. That's the ultimate plan, I would say, for a family cabin. That's assuming everything's perfect, though. There's a lot of nuance to long-term care planning and estate planning. So nobody call me up and say, the ultimate plan, give me that. We're going to look over your situation and your family situations first, and we're going to tailor it accordingly. So for more information about what we learned today, a couple places you can look. McClearLaw.com. I have a legal blog. My last 2 legal blogs have been about family cottage planning. I'm going to do a third one, and I'm going to post this video. I'm going to edit it up, and then you'll see the slides as well up on that website on the legal blog. I also have it on my Facebook page, facebook.com/McClearLaw. I often link to my blog posts, my other videos, and share information that I discover from other sources about estate planning and long-term care planning. And my YouTube page, where I have all my videos, I do not have a fancy URL. I need at least 100 people subscribe to my channel. I don't have that yet. So you go on YouTube and you just search for McClear Law Office and you will find me. And I have about, I'm not sure how many videos I have up there now, 30 maybe? This will be up there as well. Probably not for a couple of weeks, though. I got to do some editing. And with that, I'll say thank you, but here I can turn off the recording and I will take whatever questions you have.